They're nearing.
Justice, how are you? Do you need anything? Is there anything I can grab for you? Okay.
Sure.
Yes, sir.
Just for the audience, the live streaming has started. So this is being recorded and be live streamed on YouTube. And so if you were to speak out loud, you may be picked up on YouTube permanently, and that's what is on the internet. It never. So we will start the session about it. So thank you.
The only option that,
Hey, hi, how are you? Yeah, I'm Olympia.
Always the same.
All right. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
Thank you, and you may be seated. Well, welcome everyone to the session of the 10th Court of Appeals being held in Huntsville, Walker County, Texas. This is a treat for us. It is not something that we regularly do in the sense of monthly or weekly basis. but we have been doing this annually, for 13 or 14 years. It's been quite some time. We've been doing this. Our, faculty, advisor, coordinator, Professor Carl, I'll say that word, excellence, is in the back. Mike Yon, thank you for organizing this, and keeping us, coming to Sam Houston. The person that he leans on heavily is standing to his left. If my vision is right, Gene Lovell, is there. So thank you, Gene, for being here. We have two, cases set at 10, 11, and at 1:30 today. You're welcome to attend any or all of them. The way we do this in the courtroom back in Waco, where we normally sit, is that you would not be allowed to take photographs. Never sure exactly why we still have that rule, but it was developed at a time when flash bulbs and proximity were really important, and so it really was disturbing to have somebody come right up and take a photograph. But we still keep that rule there, but if you want to take a photo with your cell phone from your position without using any flash, that's acceptable. The other thing that we do differently here, because this is primarily an educational trip for you all, is that we allow the attorneys to turn to the audience and speak directly to you for 3 minutes to put the case in context, so that you will maybe better understand the arguments that they will then be making to us when they actually argue the case in court. The reason we do that is we want you to have that context in which a layperson, someone not trained in the law like we are, will better understand the arguments and what this is about. In a moment, I'll call the docket for the first case, and I'll look for announcements from counsel to make sure that they're ready to proceed and that there are any preliminary matters. The panel that will hear this case is, we are a three-judge court. My name is Tom Gray, I'm the Chief Justice. To my right is Matt Johnson. One of the justices on the board to my left is Steve Smith. The other justice this is always based on who sits to the right or left, based on seniority, number of years that they've been on the court. That applies to all public courts. The United States Supreme Court is the same way. The most junior justice, and junior is not by age, it is by length of service, will be the person to the chief's far left. That will always be the newest justice. Make sure you turn your electronics off, your phone to silent or quiet positions. There may be time for a Q&A after the second case, most definitely after the third case if you come back for that. The reason we can do this is by the legislature. They let us travel to the county seat of the counties in our district. There are 18 counties in our district. We did not get Walker County in our district until 2007. So after that is when we started coming here. We have a couple of elected officials in the audience. Will Durham is the Walker County DA. If you'll send Will, thank you. We also have the Navarre County District Attorney Will Thompson here. Since he's arguing for one of his cases on the docket, we would normally have him at the council table, but he's letting somebody else do that today. So the two DAs we are letting off today to observe. All right, the first case on the docket is Marquez versus State, 1023-021 is the appellant.
Yes, Your Honor, may I walk this for the appellant already?
Thank you, counsel.
Your Honor, Gary Lilly for the state of Texas, the appellee and state friend.
Mr. Lilly, will you be doing all of the argument or will someone else be doing part?
No, Your Honor, Jacob Shaw is also here for the state of Texas, the appellee as well.
Now, we do not allocate time. Y'all have your 3 minutes and your 17 minutes. Jacob, if he takes up all of your time, too bad.
Understood, Your Honor.
We don't stop them, we don't track it, that is completely up to y'all, okay?
Yes, Your Honor, you're prepared for that.
All right, at this time, the appellant, may approach the lectern and give the 3 minutes. And, counsel, there is a button at the bottom of that microphone that you will need to activate for the microphone.
Thank you, Your Honor. May I please support counsel? Thank you guys for allowing me to participate today. I'm really excited to be here. The criminal justice program at Henschel at St. Houston has an excellent reputation. And I've agreed to participate in this traveling forum so that hopefully you guys can learn something from the procedures and learn something from maybe a little bit about the law and learn something hopefully from what we've done in this case and from the mistakes that have been made on both sides of this case. This case involves a murder and injury to a child charge. My client, Juan Marquez, was indicted on the charge of injury to the child, and then later was also indicted for murder. I believe you have in your packet the facts as they were set out in statements that were provided to the police by Juan. So I'm not going to belabor that. But this case involves some very tricky, very complicated issues of law with regard to primarily the murder conviction and, the murder charge and the fact that the jury was instructed on the lesser included offense of manslaughter. And they indeed did convict, did acquit one of the murder, but did find her guilty of the lesser included offense of manslaughter. So a lot of the argument, and we raised 2 points of error on appeal. One of the points of error has to do with sufficiency of the evidence for the manslaughter conviction. And the manslaughter conviction involves, and that lesser included offense involves a really complicated area of the law that is quite difficult for even someone like myself who's been practicing law, criminal law for about 30 years to wrap my brain around. So I think you might find some of that interesting, but a lot of it may kind of go over your head. It goes over my head a little. But I hope that we can, that you will at least gain something from what we're here to do today.
And counsel, contrary to my comment before you started, I failed to set the time. And so, let me do that while you will follow. You may proceed when ready.
Thank you, Your Honor.
And you pull up the mic now back.
Yes. Your Honor, as stated, as I stated earlier, factually, procedurally, and legally, this is a complicated case, albeit I think unnecessarily so. I think that the indictments in the case led to some complications that may have been unnecessary, and certainly the facts of the case based on those indictments are extremely complicated. This was a over 2 week jury trial. But I'm going to try to simplify the issues as best I can before we get into the weeds, as I'm sure that we will. As I stated previously, we've raised 2 points of error. In issue number 1, we argue that the evidence is insufficient to support the jury's conviction for manslaughter. When the state requested the charge on the lesser of manslaughter at trial, we argued that the state was not entitled to the charge because there was no evidence in the record that would permit a jury to rationally find that if the defendant was guilty, she was guilty only of the lesser included offense of manslaughter. However, based on Gray versus State, 298 Southwest 3rd, 644, text from out 2009, we have determined that under the current case law, the state is not bound by this requirement. The court did permit the lesser included offense of manslaughter and also criminally negligent homicide. But we've effectively conceded that under the current case law, the state wasn't bound by the requirement, so we did not argue on appeal that the lesser included offense was improperly submitted to the jury. The validity of Gray, however, when applied to cases involving manslaughter and other lesser included offenses involving recklessness, is an issue that is ripe for appeal. Although it's not argued in our case, it has some bearing on where we're going with our appeal in this case. The appellant in the case of Dean versus State, and I can give the court a citation in a minute, but this is a case involving a police shooting in the Tatiana Jefferson in Tarrant County, and they raised the argument seeking to challenge the officer's conviction for the lesser included offense of manslaughter in his murder trial. We've not made that argument on appeal, but there's a similar problem in this case involving the sufficiency evidence that we raised. The issue that they raised was the submission of the lesser included offense to the jury in the first place. We recognize that, and albeit only after preparation for this argument, that our argument, sufficiency argument in particular, is affected by Ramos versus State, 487 Southwest 3rd, 265, Text Crim Act, 2013. We have argued that the evidence is insufficient to support the appellant's conviction for the lesser included offense of manslaughter based on the two theories advanced by the state in the murder indictment. The jury was charged on these two theories, namely those two, manner and means. And they were charged not only on the two theories under the murder section, but also under the section involving the lesser included offenses. The jury was charged that if they found manslaughter, they would have to find that the appellant recklessly caused the death of the alleged victim, or the victim's case, Amberly Quiros. They would have had found that she either recklessly administered a toxic dose of tramadol or recklessly poured the pot of boiling water over Amberly's head. Under Ramos versus State, however, the court found, and that's a case out of 2013, the court found that the lesser included offense of manslaughter did not require the submission of, well, let me back up. That in a sufficiency analysis on a lesser included offense of manslaughter, that the court was not bound by the manner and means alleged in the indictment. That particular case was a lesser included offense case. There were manner and means that were alleged in the murder indictment, but they were not submitted to the jury in the jury charge. And that was a case that involved a variance, or at least the court determined it based on a variance between the proof at trial and the alleged manners and means. We can see that under Ramos, hypothetically correct jury charge would not have required proof of a specific manner and means. That was largely what we argued in our brief, but after discovering Ramos, we can see that that case is precedent to this court. We do argue, however, that the decision in Ramos was too broad and that it fails to take into account the difference between the pleading requirements of a result of conduct offense involving recklessness like manslaughter and a result of conduct offense involving an intentional or even a result of a case involving, an intentional or knowing mens rea, like murder. That case, Ramos doesn't take that difference into an account, and we find that problematic. We would adopt the reasoning of a concurrence in Ramos, that the majority decision in Ramos leads to an irrational result in which the state is required to plead specific acts of recklessness under the heightened, pleading requirements of 2115 of the Texas Code of Criminal Procedure, but then they turn around and they're not required to prove them. While we understand that this court is bound by the precedent set in Ramos, we believe the decision is ripe for reconsideration by the Court of Criminal Appeals, particularly in light of the issues raised in the Dean case that I brought up, that will almost certainly be raised on PDR. I would also,
Counsel,
yes,
where that court that's stuck in the,
Yes.
between the trial court and the CTA, you've
Yes.
argued, a different theory of the problem, this morning involved in your brief, the addition of Ramos and the, precedent.
yes, sir.
How are we as an intermediate appellate court, bound by the record that's in front of us and the issue that agree, going to be able to reach the issue that you are arguing with regard to, whether or not we are doing our our legal sufficiency review of the evidence, whether or not this jury had legally sufficient evidence to find guilt on the manslaughter.
Well, I'm still going to argue, to the court. I believe the court is, even though it's not cited in the brief, obviously the court is going to have to consider Ramos in its sufficiency evaluation. I raised the issue that, and
Is that going to be under our requirement to evaluate the sufficiency of the evidence under a hypothetically correct jury charge?
yes, sir,
Okay,
yes, sir.
I see how you're getting this.
Yes, and so but we are still going to argue that even under the hypothetical, hypothetically correct jury charge, that there was insufficient evidence. But that changes the structure, that changes, basically the arguments that were made in the brief, and really adds an addition of failure to exercise, or failure to seek medical care, which would be the other issue that was raised by the facts, and whether that can be considered as sufficiency of the evidence of recklessness. And so I think, I think that's a problem, for us, but I do, think that there is an argument to be made that the, that even with the addition of that and the under Ramos, the court's ability to take that into consideration, then, I do believe that there is still an argument to be made. I also believe that, that recognizing Ramos, that it's incumbent upon me to raise the issue in this lower court that Ramos was wrongly decided.
Okay.
And that so that we may be able to address that given what the court's decision is here, to the Court of Criminal Appeals.
Okay, so let's go with the idea that Ramos may modify from what the time we briefed it, with Ramos and Dean, that the hypothetically jury charge may be a little different than, at the time we briefed or as briefed, and move on to the part of the argument about why is the evidence insufficient under that hypothetical jury.
Yes, Your Honor. And I will also state that my arguments in the brief, I believe, and really in my mind, kind of go back and forth between the result of conduct and the nature of conduct, dichotomy or difference in the law, which is indeed a really hyper-technical area of the law. And so, but what the ultimate issue boils down to, whether you're looking at
the specific acts that were alleged, or whether you add in the failure to seek medical care element. What we're really looking at, because this is a result-oriented, offense, we're looking at whether or not the appellant knew that there was a risk of death in the acts or omissions that, she did or failed to do. And I knew that there was a substantial risk of death and disregarded that risk. Okay, so I have advanced several arguments in the brief for, whether or not for the fact that, she did not know that this was a risk. There are some arguments that these things were not, proven to be substantial risks. And not having a whole lot of time and not able to taking them individually, I think I'll focus, basically on each, I think it's incumbent upon me to take each one individually. And you also have to look at what the jury found in or did not find in their acquittal for the offense of murder. This is a strange, albeit allowed under the law, but a difficult murder indictment. The state alleged in the murder indictment that the appellant, intentionally or knowingly, with the intent to cause serious bodily injury, a specific intent, committed an act clearly dangerous to human life, and alleged a tramadol incident and pouring the water over the head of the child. So, both of those, the jury did not agree with and acquitted of murder. So there are three elements that they would have had to have not found. They either didn't find that she had the intent to commit, serious bodily injury. They found that she didn't do the acts at all, or they found that the acts were not clearly dangerous to human life. If they found that she didn't do the acts at all, then we get to a sufficiency issue on whether she recklessly committed those acts. If they found that the acts weren't clearly dangerous to human life, then how can they be reckless? How can it be argued that she disregarded a known substantial risk of death, when the jury found that they were not acts clearly dangerous to human life? And then finally, they could have found that, I said that she didn't commit the acts at all. I laid out in the brief several reasons why we believe that a rational juror would have found reasonable doubt with respect to those offenses, and I think that's buttressed by the acquittal on the murder charge. With respect to failure to seek medical care, I think that's been the main issue in this case for the entire time. The pictures, and I'm not sure if the state has the ability to show those. They were intending to show those here today, but the pictures are horrific. So the argument would be, the issue would be, did the appellant recognize, or did she know that there was a substantial risk of death in failing to seek medical care? And we would point the court to the entire day-long testimony of Dr. Kondawal. Dr. Kondawal was admittedly one of the country's leading burn experts out of Ohio. And he testified that out of the thousands and thousands and thousands of burn patients that he had seen, that it was not unreasonable that the appellant's story that the burns did not appear that severe in the initial hours before they went to bed was completely reasonable, and further testified that that it is a substantial part of his practice to teach emergency room physicians, other physicians and EMTs, and educate them on the dangers of burns that don't appear severe in the beginning if they can become severe. And I think that testimony was extremely powerful with respect to that, and that a rational juror would not have been able to disregard that testimony, which supported the appellant's story that she was, that she did not understand or know the risk of death, even in light, in failing to seek medical care, even in light of the severe nature of the photographs and the injuries that were depicted in those photographs and that the officer saw on the morning, after they were all awakened and the appellant discovered the child dead.
Thank you, Counsel. Counsel, you may begin with your 3 minutes, for the lecture and turn the mic on.
Yes, Your Honor. Okay, please support, counsel. Thank you all for having me. My name is Aaron Lilly. I'm an assistant district attorney in Barrow County. My co-counsel is Jacob Shaw, who's also an assistant district attorney. And today, we're here to argue the appellant Juan Marquez's conviction. She was convicted of manslaughter for pouring a pot of boiling water over her 4-year-old child. After she did that, she gave the child tramadol and failed to seek emergency care. So the next morning, police found 4-year-old Amberly Heroes in her bed, severely burned. And there's 2 issues here on appeal. There's the sufficiency of the evidence, and there are extraneous acts. Now, while the jury found Juan Marquez guilty of manslaughter, the state's argument is that the evidence was sufficient to convict her of murder. Under section 6.02E of the penal code, it says that proof of a higher degree of culpability than that charge constitutes proof of the culpability charge. Thus, we contend that Juan Marquez intentionally caused the death of Amberly, which as a matter of law is sufficient for a finding of recklessly causing the death of Amberly. Now, effectively, our position is that Juan Marquez got away with murder. All right? And that being said, the evidence is still sufficient to support her conviction of manslaughter. Now, at trial, the state introduced photos of extraneous bad acts done by Juan Marquez, where there was evidence of abusing other children in the home. Now, those were argued under the Texas Rules of Evidence 404B and the Texas Code of Criminal Procedure 38371. And of course, this appeal follows. I'm going to argue the sufficiency of the evidence, and my co-counsel, Mr. Shaw, is going to argue 404 and 404B and 38371.
You may proceed, you're ready.
Thank you, Your Honor. Now, as this court is aware, the court must affirm the trial court's verdict unless, viewing the evidence in the light most favorable to the verdict, any rational fact finder could not have found the essential elements of the offense beyond a reasonable doubt, which is an objective test based on a hypothetical rational fact finder. Now, the appellant argues that no rational fact finder could have found Juan Marquez guilty of manslaughter beyond a reasonable doubt. The appellant essentially said that this was a tragic accident and argued this at the trial court level, that Amberly had pulled a pot of water or dumped it on top of herself. However, the jury is free to believe or not believe each piece of evidence and to put whatever weight on the testimony and evidence for them. They're the exclusive judges in that regard. Now, the court is to presume that the jury resolved any conflicts in testimony or evidence in favor of their verdict. And of course, the state is not required to disprove any alternative theories advanced by a defendant that may be inconsistent with their guilt. Now, as Ms. Watkins said, Dr. Cantwell testified that to a medical certainty, that Amberly picked up the pot off the stove and dumped the water onto herself. Not that she simply pulled the pot of boiling water off the stove. Amberly was 42 inches tall and the stove was 35 inches high. For her to have gotten those burns onto her face and the upper extremities and chest torso portion of her body, she would have had to have picked the pot up off the stove and dumped it like this. Now, of course, the state argued at trial that Amberly was in a bathtub, partially filled with water, and that the appellant dumped the pot of boiling water onto Amberly. Now, when Detective Harrell and other officers arrived, the appellant said that Amberly pulled the pot onto herself. The detectives found that the physical evidence was inconsistent with the appellant's story. There was undisturbed dust under the stove. There was dust and grease that remained on top of the stove. And according to the appellant, there was no cleanup of the water because all the water went onto Amberly and it was soaked up by her dress. However, when detective showed up, there was no evidence of the dress being wet at all, nearly 12 hours after the incident had occurred. There was also a clear line where the burns stopped on Amberly's chest and back, and there were no burns below her mid-chest or back. There was no evidence, as I said, about the dress being wet, and appellant made no mention of giving Amberly tramadol, which the medical examiner, Dr. Gruzecki, found in Amberly's blood system in a potentially toxic concentration. Now, if Amberly appeared okay or just thirsty, as the appellant alleged, then why did the appellant feel the need to give Amberly tramadol? And further, if the injuries were so severe that she had to give Amberly tramadol, why didn't she call for emergency care? Now, Ruben was Amberly's 6-year-old brother at the time. He and Angel, he said that he and Angel, his younger brother, were being bathed by the appellant, and after their bath, he went and told Amberly to get undressed and go to the bathroom for her bath. While in his bedroom, after leaving and Amberly going into the bathroom, he heard Amberly scream, so he ran through the house frantically trying to find Amberly and looked in every room except for the bathroom, but he was unable to find her.
Counsel, as I recall briefly, Ruben also testified that he recalls something in the kitchen being wet.
Yes, Your Honor. I believe after he testified to that, he also testified that he did not recall saying that.
And is it the state's position that beyond the act of whatever happened with the boiling water and the administration of the tramadol, that the failure to seek medical care alone would support the judgment, or is that just part of the fabric of the case?
No, Your Honor, the state's position is that the jury could have found that failing to seek medical care was in itself reckless. They could have also found the administration of tramadol to
And
be
does that
reckless.
get back to the question of Ramos and Dean, the opposing counsel was now arguing that the manner and means for the recklessness is not limited to the manner and means of the allegation regarding murder.
Yes, Your Honor.
Okay.
Continuing, when Ruben woke up, Amberly was on the floor and she was unresponsive. And the appellant, Juana Marquez, told Ruben that Amberly had gotten soap in her eyes and turned on the hot water, which caused her burns, which was also inconsistent with what she told Detective Harrell. Now, Dr. Candelwall, the defense appellant's burn expert, said again to a medical certainty that Amberly picked up the pot using both handles and dumped the pot of boiling water onto herself. In fact, he performed an in-court demonstration where he had the pot up and was performing a dumping action. Now, he also said that the boiling water that caused such severe burns to Amberly's upper body and limbs would have cooled in the 41 inches that it would have taken to get from her head down to her feet. And that's why there were no burns on her feet. But this also doesn't answer why there were no burns below the mid-torso of Amberly's body. There were no burns to her legs, there were no burns to her buttocks. And it's wild to think that boiling water, which is at least 212 degrees, would have cooled in the mere seconds that it would have taken to go from her head to her feet. That's bizarre. One other thing that Dr. Cannonball was never informed of is that he was never told that Reuben had been told by appellant that Amberly burned herself in the bathtub when she turned on the hot water. Now, Dr. Grzecki said that Amberly's death was a homicide and that she died as a result of complications of thermal burns and that the toxic effects of tramadol contributed to her death. Dr. Suzanne Dakill, who's the medical director at the REACH program at Children's Hospital in Dallas, found that appellant's version of what happened was highly implausible. Amberly would not have grabbed the pot by the side as it would have been hot. She found it more plausible that Amberly's burns had occurred in the bathtub, partially filled with water, with the boiling water being poured directly over her head. All three medical experts, regardless, opined that Amberly's injuries were survivable had immediate care been sought. Amberly suffered severe burns over 45% of her body. Not seeking immediate medical care was a known risk of possible death. Appellant said that she didn't seek immediate emergency care because there were other children in the home, and assumably she didn't want to wake them. All three also opined that tramadol was not for use in children. And again, that could be seen as reckless by the jury. Now, at trial, there were only two theories that were presented. The appellant said that Amberly pulled the pot of boiling water on herself, which, if that's true, it's a tragic accident. And of course, the state argued that the appellant, Juana Marquez, dumped the pot of boiling water onto Amberly while she was in the bathtub, intentionally causing Amberly's death. And again, it's murder.
Would the jury have been limited under the theory of that they convicted on? Would the jury have been prohibited from considering whether or not boiling a pot of water while you were tending the two brothers in the bath, while there was a 4-year-old unattended in the home, whether or not that alone would be reckless?
Yes, they could have considered that as well.
Okay.
But the jury is assumed to have resolved any issues in favor of their
The
verdict.
recklessness of the manner and means is not limited to the manner and means of a murder charge, is what you're telling.
Yes, Your Honor.
Okay.
Now, it's clear from the jury's verdict that they did not buy the appellant's theory or their witnesses' assertions that Amberly had poured the pot of boiling water on herself. But based on the jury's finding of not guilty to the charge of murder, it also appears that they didn't believe the state's assertion that the appellant intentionally caused the death of Amberly. And in summation, there's several reasons why the jury could have found Juana Marquez guilty of manslaughter. The actions were reckless as she didn't intend to cause the death of Amberly or serious bodily injury, but were to merely punish her, and that it was a case of excessive punishment. Appellant had just bathed Reuben and Angel, and perhaps her intent was to accelerate the heating up of the bath water again, as she had just used it all up. Giving tramadol was reckless. Not seeking emergency medical care was reckless. They could have found that appellant probably did it intentionally, but not beyond a reasonable doubt. Any way you look at it, the jury could have found recklessly for several reasons, and the evidence is clearly sufficient to support that finding. Now, I'm going to defer to my co-counsel to address the second issue.
Thank you, Captain.
Please, the court, co-counsel. I'm going to jump to what I think is the most dispositive argument that I have on this issue of the 404B and the 38371 analysis. To focus the issue, the evidence at issue here consists of a number of photographs of bruising on Reuben and Angel, siblings of the victim, that are remarkably similar to the bruising that can be seen on the autopsy photographs of the victim in this case. But again, obviously, it's not available to testify about the nature of those bruises at trial. Additionally, a statement that was made by Ruben to Megan Stovall, a CPS worker who testified in the case that the bruising, or at least one of the bruises, was caused by a pellet. There is other evidence that comes in regarding this, but the large majority of it is either rebuttal from the defense or further clarification. The most dispositive issue, I believe, is that the appellant has failed to show harm. Even assuming that the evidence was admitted erroneously or even used solely for character conformity purposes, the appellant has failed to demonstrate any adequate harm. The photographs and statements of this abuse go directly to the appellant's intent and whether or not this was an accident. It also shows a relationship of abuse between the appellant and the victim. Despite this evidence of intentional harm, the jury declined to find the appellant guilty of intentional harm or intentional killing of Amberly. As this court is well aware, the erroneous inclusion of evidence is a non-constitutional error to be disregarded, should it not have influenced the jury or merely have a slight effect. This evidence clearly, based on their verdict, did not have a significant effect on the jury. It's in direct contrast.
Let me interrupt you just a second. Typically, the 404 analysis that a trial judge has to make, sometimes they look at similarities. Now, what if any court is for us in considering whether or not this was an error by the trial judge, is that you're asking us to equate bruises on a body with burns caused by boiling water.
Yes, Your
I
Honor.
understand that, I can understand that this person has been beaten to death, but is there any consideration given to the type of conduct in this case? And does that mitigate for or against the admissibility of evidence?
Yes, Your Honor. I would argue it goes in favor of the admission of this evidence. Specifically would be, why is this evidence even relevant, right? Which I think is kind of the heart of your question. This evidence is relevant specifically because it goes to two permissible purposes under 404B, one being the lack of accident. The defendant's essential claim here, the defensive theory that we are attempting to rebut, is that this was accidentally done. This is highly probative evidence for the jury to understand the relationship between the defendant and the appellant at that time, the defendant and the victim. That relationship evidence being admissible under 38371. It also goes to show motive. It reveals to the jury, well, why might this pot have ended up poured over the top of Amberly? Well, because of that motive that is common to all or most abusers of children, would be my answer to that. Further, I would argue that the defense's opening statements kind of kick this door wide open as far as intent and accident go. I have a couple of quotes here from opening statements. The evidence will show that Juan Marquez did not intentionally injure the victim. There is no evidence that she intended to hurt that little girl in any way. No evidence that Amberly's injuries were intentionally inflicted. Trial counsel then tells the jury, it is not a quote, but a paraphrase, that the appellant will take the stand and tell them what happened. And lastly, she refers to the appellant as a sweet lady. From the very, very beginning of trial, this is a tragic accident. And this evidence goes to make whether or not this was a tragic accident significantly less likely.
Did I understand you to say when you first started that there were some photographs of the victim that were bruising that were similar to what was on,
Ruben and Angel, Your Honor, yes. We have the pictures here with us. Looking at State's Exhibit 23, this is what was admitted at the hearing, but it consists of photos also admitted into evidence. On State's Exhibit 23, you can see physically below the burns, there are a number of small, some larger bruising. This same bruising can be seen on the same parts. This here would be Angel and Ruben as well. The other piece of evidence, this picture is not particularly good, but you can see that the highlighted circles from this showing up here. Similar bruising on the lower to mid back and torso and on the
wasn't a comparison of bruising to burns. You're saying there were bruising on both the victim and her brother.
Yes, Your Honor, and that's the key point of relevance here, is that bruising is highly indicative of why was there bruising on this victim? Why was that shown at the autopsy? Of course, she can't come to trial and tell us. And so the best thing the state was able to bring, I mean, this is highly necessary evidence for us. The best thing that we were able to bring is another child who lived in the home with similar, if not identical bruising, who came and eventually on defense's cross-examination told the court, you know, I think the exact quote was, time out men getting beat, right? And then earlier at trial, we did a statement that where he pointed to a bruise on his thigh saying that that was caused by the appellant. It's highly indicative of the nature of the relationship between the appellant and the victim. And just briefly to finish up here, well, that's fine.
Thank you, Kevin.
Thank you. First of all, I'd just like to clarify some statements that were made by Mr. Shaw with regard to, and Mr. Lilly with regard to some of the testimony. Again, this is an extremely long trial, and these two gentlemen, capable gentlemen here, did not participate in that trial. And so there are some things, which is why I requested oral argument in the first place, with regard to demonstrations that really are helped by the oral argument. Dr. Condawall, they said that Dr. Condawall testified to a degree of medical certainty that, and performed a specific demonstration of the child lifting up the pot and dumping it over her head. That was the subject of a very, very lengthy back and forth between the district attorney and Dr. Condawall, in which the district attorney is continuing to ask him to demonstrate, while the district attorney is demonstrating ways and manners himself. And Dr. Condawall, finally, out of what seemed to be frustration, picked it up and demonstrated one way of how it could have happened. There was on redirect and re-redirect and over, there were several times that Dr. Condawall repeatedly stated, we cannot, there are a number of ways that this could have happened where she picked, she pulled the water over onto herself. And I'm not committing myself to the one specific way that he demonstrated at the continual request of the district attorney to make that demonstration. So that's a mischaracterization of his testimony for what it's worth in the consideration today. Also, with respect to Ruben and what he said about the incident, he did say that he stepped in water when he went into the kitchen, and he did not ever say that he didn't say that. He said it in court. It wasn't on a video. He said it in response to a question that was asked by the co-counsel, and it was really unresponsive. She said, "Did you see water?" And he said, "I think I stepped in water." And so that wasn't something that he came back and said, "I never said that." He actually did say that, and he never contradicted that he didn't say that. With respect to the arguments on recklessness, we throw around this term reckless. It was reckless. But the court obviously knows that you have to be concerned with the specific legal definition of reckless. In any of these scenarios, did the appellant know that there was a substantial risk of death? And did she disregard that substantial risk of death with any of the actions that, or omissions that were taken? The court asked whether or not the jury was able to consider whether or not, leaving a pot of boiling water on the stove during the bath. No, the jury wasn't able to consider that. The jury was specifically instructed that they were only to consider the tramadol and the pouring of water over her head. Can this court consider that in the sufficiency analysis? I assume that under Ramos, this court could consider that. Again, we argue that Ramos was wrongly decided, and that the jury should have been limited only to those two particular acts that were alleged in the murder indictment because of 21.15 of the Texas Code of Criminal Procedure and those, pleading requirements.
So your argument in opposition to the state's, characterization that under what you think Ramos needs to hold, is that we would be limited in considering only those manner and means that were alleged in the murder indictment on the, manslaughter.
Yeah, because if you have a manslaughter indictment, it would have been governed by 2115. And if it was governed by 2115, they would have had to plead those, for the notice requirements. And as Justice Alcala in the Court of Criminal Appeals stated, why would you be required to plead them if you're not required to prove them? That's irrational. And so that's the basis of that argument. Addressing very quickly, Your Honor, the lack of accident on the 404B. The state again mischaracterizes the lack of accident. That would have made sense if we were talking about whether or not the appellant accidentally did something versus intentionally did something. But that's not the issue here. The issue is whether Amberly accidentally did it versus the appellant actually did it. So the lack of accident doesn't make sense in that context. And I think the state fails to understand that. With respect to motive and Justice Smith's comments, I think it is also important to note that the bruising, how you get from causing bruises, and particularly the small nature, the minimal bruises that were on the children. And I don't have time to point out, but the court can go back and point out and see in the testimony where those bruises were, they're circled. But the minimal nature of those bruising versus the jump to, oh, that's motive, to pour a pot of boiling water over the defendant, over the child, that doesn't make sense as well. So we would argue that the court abuses discretion and that did harm the appellant because it allowed them to paint her as a monster throughout the trial. And that was a significant part of the way that they were able to do that and to make those arguments. Thank you.
I do have a question.
Sure.
In your brief, you say all jurors found that there was a reasonable doubt whether the appellant intentionally committed an act clearly dangerous to human. Okay, don't juries fail to find when a case is put on, they fail to find beyond the reasonable doubt. And does that may be to some degree just semantics, but I think it does make a difference. Factoring that, if we're limited to only the manner and means of murder, the jury didn't find anything. They failed. And does that affect your argument in some way, or how should we analyze it? Because that's the way I would look at it today.
Well, and I think they failed to find either one of several things, right? And I think that is also something that is extremely problematic with this case because this is not simply a lesser included of manslaughter to an intentional or knowing murder, right? This is a lesser included of manslaughter to intent to cause serious bodily injury, right? And so if they fail to find an intent to cause serious bodily injury, that's a lot closer to not finding recklessness than intentional or knowingly causing the act. And I'm not sure if I explained that fully, but to the court's satisfaction. But that's what I got.
Thank you very much.
All right, thank you.
Thank you, counsel. This case is submitted to the SHSU, and we'll start back at the same case shortly after 11 o'clock. Thank you.
Yes, watch Thank you.
Yeah.
Yeah.
I know, I was afraid they were gonna make me do that. They're all.
But we had to turn 45 people away from the first hearing, so if anybody is willing to give up their seat, so the people who waited can do so. We would appreciate that, but if you're learning, you can say something. Well, that's fine. Thank you very much.
Oh, okay.
Morgan. Let's go ahead and.
Amy's a small thing. She doesn't stay together. Data times and all those sort of like. Yeah, so she. Yes, I met her. I mean,
I mean, but some of us are yeah. Just being here this year, I know. I'm gonna go check. I'll be right back. Oh, I'm gonna go check with pedestrian, but I'll be right back.
Wait till you get back.
Yes.
All rise. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. I want to welcome everyone to the 11 o'clock docket call for the 10th Court of Appeals from Texas. We're holding it today on the San Houston State University campus, and it is really a pleasure for us to be here. I told my grandchildren that I was going to get to meet the president today, and they were all excited, and they said, well, I didn't think Biden was going to be in Texas. No. I'm gonna get to meet the president that really matters, is President White. President White, very good to have you today. We will tender the floor to you if you would like to say anything.
Your Honor, I'm just delighted that you are here today on our campus, providing this opportunity for all of us to see how justice works. We thank you for your service for the great state.
Thank you, President White. It really is good for me individually to be back on the San Houston campus. I graduated from here in 1978 out of business school, went on to another couple of degrees, including a law degree. But when I graduated, this building was being built. And so then some 20, 30 years later, I stepped to the back of the room where the students, where you come in back here in the back. And I just remember the awe that I had of the forward thinking of the San Houston trustees to build this facility as they did at the time. And this incredible courtroom that you all get to benefit from and see a functioning courtroom, real cases, real problems that have to be decided. And this court, this 10th Court of Appeals, it sits over 18 counties in central Texas, Walker County being one of those. I think I may have just said 16. 16 was what it was when I was first elected. It is now 18 counties in central Texas, and Walker County was not one of those original 16. It was added in 2007, and shortly thereafter, Professor Mike Yawn, where are you, Mike? You must be outside or in the overflow room with the other students. He contacted me and we started doing this on an annual basis. And it, I believe, has been a real addition to the student curriculum for a number of programs in which Mike is involved. So we very much appreciate our host and the program that he leads every year. And even in that process, I've actually run into him in Austin, Texas, in the Capitol with some of his students. So it really is great to be involved in that program. You were here at the earlier program at 10 o'clock. We had one of the students in his program call us off, and I'm looking for her name here. I was sure I had Cynthia Villarreal. And so thank you, Cynthia, for doing it this morning. And then Morgan, thank you, Morgan. I'm sorry, another one of his students became our clerk for second docket today. And so our clerk was unable to travel with us today, and so we drafted a couple of my students to do that. To my right is Justice Justice Johnson. Thank you, Matt. Yeah, start forgetting names, get them all. And he sits to my right, Steve Smith sits to my left. That is based on seniority on the court. It has nothing to do with age, purely a length of service, which means that, and it's that way on any appellate court. So if you look at the United States Supreme Court, the justice that is furthest to the left of the Chief Justice will be the newest judge on the court. And so it literally just goes back, regardless of if it's 3, 7, 13, 9, whatever the number is, if they are sitting in bond, then that's the way, the seating arrangement is located. I mentioned holding this in Huntsville, Walker County. We can travel, but we can only sit in the county seat of the, county that are in our district. What that means is that, we can come to St. State and hold court here in this county seat. We cannot do that on the A&M campus, over in Bradford County, because A&M is not located in a county seat. So all your Aggie friends, you can ribbon that we can be here, but not there. So, I would have to hang a small footnote on that. The Constitution and legislation that authorizes the Texas Supreme Court to meet over there, and one of the things that you need to be aware of is notwithstanding the folks sitting over here in this box, they are not a jury. There will be no, jury today, there will be no fact finding, and you will not learn a result of today's action until sometime later. And that's if you will go to the court's website. It is listed in the little pamphlet that is handed out with the case summaries, and you can sign up for what is called case mail. That is the way to follow what happens after today. After these lawyers make their arguments to us, we will go back to Waco and write an opinion. We will circulate that opinion, and if it gets a couple of votes, then it will be issued. Anytime something happens after today in any of the 3 cases that are argued here today, there will be an email that goes out that says, some activity. And then you can go to the court's website, you can look at that case, and you can see what has happened, and if it is a document that is being issued, you can go to the document, read it, and find out what has happened. That's the way to keep up with what happens after today and our holding in this case. We have a couple of our court staff working, traveling with us today, and if you expect me to remember your name, Audrey Sweet and Lindsay Adams. So they are career attorneys. So those of you all that are looking at attorney careers, this is an option that you may want to investigate, and you need to track them and ask them questions about that. Please be sure you turn off all your electronics. 2 things we do different when we travel that we do not do at our courtroom in Waco. We let y'all take pictures from the audience as long as you don't have it flash on your camera. And you can't move around to get a better photograph. And so we let that occur here. The other thing that we do, and this is for y'all's benefit, is we ask the attorney to turn to you and speak for 3 minutes before they start their argument, to place their case in context so that you understand the legal arguments that they will then turn and make to us. It's an informal session of 3 minutes, and so they get to do with that whatever they will. Then they will spend their 17 minutes, turn back to us, making their legal argument. Anything else? All right, at this time, I'm going to call the docket, and I would like to announce of the attorneys that are going to be arguing the case. Lamb Moran versus the state of Texas.
Andrea Bedeker, present for appellant, and we are ready.
David Barnum, state of Texas, Johnson County. Right. David, I don't see what date my docket sheet was prepared, but as of the date that it was prepared, you have not made an appearance yet in writing in the case, and we will need you
employee issue, and we will remind you to be able to do that, if we need to do that. But the only attorneys that we had in the station judge, they have him. And so the district attorney in the trial attorney. I don't think he made an appearance that didn't get recorded, but we'll need to do that, it's just a bit of paper. No problem.
Jason is no longer, he's at Parker County.
Right. And I failed to introduce any elected officials in the office, in the audience. I don't see any, that stay. We had the Walker County District Attorney here, at the first session, but, Andre, you may approach the lectern, turn the microphone over towards you, and you can stand on this side. I will let you know if you exceed the 3 minutes.
Yes, sir. May it please the board?
You may proceed to record.
Short, pointed down. So I'm Andrea Becker. I am a criminal defense attorney in Johnson County, Texas. I'm a member of a small firm at Arthur Becker in Canada. I represent criminals on appeals and in trial level, but specifically for this case, I was appointed as the appellate counsel to review the transcripts of trial, all the evidence presented at trial, and to try to determine if there were any appellate issues to write about. So my client, Vaughn Moran, was indicted in May 2021 on one count of continuous sexual abuse of a young child and one count of sexual assault of a child. It stemmed from allegations by his 15-year-old adopted daughter, and we're going to use a pseudonym, and the pseudonym is Rachel Turner. We use a pseudonym to protect the identity of the child. 2 days after his arrest, Detective Wesley Mackey conducted a custodial interrogation of Loran at the Johnson County Jail. Loran's first language is Marshallese. He was born in Marshall Islands and came here in approximately the year 2000. And while he can engage in some conversational English, he is not fluent. Detective Mackey read Loran his Miranda rights. Now, Miranda rights, some of you may know, but essentially, the one that we're going to touch on today are the right to remain silent, and that any words you use can and may be used against you in court of law. He was read those rights in English, and the entire interview was conducted in English. At no point was Loran asked if he could speak or read English language. Loran was unaware he could request a Marshallese interpreter and did not understand his statements to be used against him in court. During the interview, Loran confessed to inappropriately touching Rachel on multiple occasions starting in 2018. Loran's trial attorney filed a motion to suppress the interview, arguing Loran did not knowingly and voluntarily waive his Miranda rights. The trial court denied the motion at her hearing. At trial, the interview was admitted over objection in front of the jury. The jury found Loran guilty of both continuous sexual abuse of a young child and sexual assault of a child. He was sentenced to 44 years on a continuous count and 20 years of sexual assault counts. We have 3 points on appeal. One is that the court erred in denying motion to suppress because his waiver was not knowingly and voluntarily. The jury charged the continuous sexual abuse count was erroneous because it did not require the jury to find 2 acts occurred at least 30 days apart, which is essential, and the trial court improperly ordered Loran to repay court-appointed attorney's fees without finding that the contingency had changed.
4 seconds on May.
May it please the court.
Pull the mic back.
You may proceed to the record.
Thank you. My name is Andrea Becker, and I represent the appellant, Vaughn Moran, in this important case before the Honorable 10th Court of Appeals. I will be addressing 3 issues in my argument today. First, that the trial court committed reversible error by denying Mr. Moran's motion to suppress his recorded statements when his Miranda warnings were given in English, which is not his first language, and he did not understand that his statements could be used against him in court. Second, whether the jury charge on the offense of continuous sexual abuse of a young child contained egregious error by failing to require a finding that the alleged acts occurred 30 or more days apart, which is an essential element of the statute. And finally, my third point is whether the trial court improperly ordered appellant to repay court-appointed attorney's fees without determining he had the financial resources to do so. I will address all of these issues in turn, but before diving in, I want to emphasize the importance of protecting the constitutional rights of all criminal defendants, including those who may not have a full mastery of the English language. The right to remain silent, the right to an attorney, and the right to have a jury determine guilt beyond a reasonable doubt on every element are bedrock principles of our criminal justice system. When those rights are violated, as they were here, it undermines the fairness and integrity of the entire process. That is why it is critical that this court rectify the errors that occurred in trial level. Turning to the first issue, the trial court committed clear, reversible error by denying appellant's motion to suppress its recorded statements to Detective Mackey. An appellate court reviews a trial court's ruling on a motion to suppress based on an alleged Miranda violation with a fabricated standard of review, giving almost total deference to the trial court's ruling on historical facts and application of law to fact questions that turn on credibility and demeanor, but reviewing de novo the trial court's rulings on application of law to fact questions that do not turn on credibility and demeanor.
Counsel, this is a situation where there was the motion to suppress and the evidence obtained at that motion, presented at that motion. But there may have been some preliminary hearings. It seems like your brief relies in part upon what occurred to show the defendant's confusion about language at those hearings. Two questions. Was it the same judge at those hearings as at the motion to suppress hearing? And can we rely upon something that was not presented at the motion to suppress hearing?
Yes, Your Honor. Judge Cindy Hewlett was the judge throughout the entire process, including the arraignment hearing where I believe you're referring to. And yes, Your Honor, it is my belief that all of that can be taken into account because that's all record before the court.
Good.
So the state must prove that the defendant's waiver of Miranda was a knowing, intelligent, and voluntary under Miranda itself. So I'll jump ahead to talk about that arraignment hearing. At the arraignment hearing, the Honorable Judge Hewlett had concerns about my client's ability to understand the English language. She was going over his indigency because as he appeared in court in custody, he did not have an attorney present with him. And she asked him, she said, "Do you have an attorney? And are you able to hire one?" And he's like, "Yes, I cannot afford an attorney." And then she's like, "Well, did you apply for one?" "Yes, I told them I need an attorney." So then she starts going through her process that she generally goes through about, is the person indigent, including, do you own an ATV or boat? And the defendant responded, or appellant responded with, "I have a laptop." And she's like, "Okay, so you have a computer?" "No, I have a laptop." And so she, then from what I can tell, she points to the court reporter's computer and says, "Is this what you have?" And that's when they understood that he was having issues understanding laptop was the same thing as a computer. So at that point, Judge Hewlett took it upon herself to appoint not one, but two Marshall Lee's interpreters to represent Mr. Lorraine in all future court proceedings.
Counsel, and this is sort of a footnote on my East Texas upbringing, I should say. I don't know what Marshallese is. We don't know what its root language is. Is it Spanish? Is it English? French? Do we know?
I'm unaware. I do know that it is the first language of Marshall Island. They do teach English as a second language, and they do begin that at a young age. However, later on, I believe in volume 10 of the transcripts, the interpreters discussed with the judge that the Marshallese language does not have specific words that connect with our English legal terminology. And so that's why there were two interpreters involved in the process so that they could work together and tag team throughout the interpretation piece.
And you're using the word interpreter, and interpretation is different than I can't remember the other. Translation. translated versus interpreted. Does that impact our case at all?
I don't believe so, Your Honor. They were required to interpret and translate as the court required for their proceedings.
And were they state certified?
There is not a state certification for marshallese. However, the judge went through a process with them and said, you know, if a terminology comes up that you don't have a answer for, raise your hand and say legal term and we'll work through it. Based on what I saw in the transcript, I never thought that happened during the trial.
And is it your position that the fact that Judge Hewlett appointed interpreters, that has some bearing, because that's a judicial proceeding, technical language, that has some bearing or control over whether or not an interpreter should have been used at the time of this question?
I think it's very persuasive information, Your Honor. She herself deals with clients or defendants on a day-to-day basis, and she did not feel that this individual understood English enough to be able to arraign himself. So therefore, that's why, you know, he was appointed. Further, at the trial, the state had a marshallese individual testify on their own behalf. And he had been in the United States for many years, beyond how long my client had been there. And he even said, you know, in this legal surrounding, I would feel more comfortable if I had the services of the interpreter translator, while he was on the witness stand. And so that was allowed as well.
Now, this interrogation that was done by the police officer was done in conformity with the statute on recording and giving the statement, the warnings. But you contend that you did not understand. You're not suggesting that the police officer did anything wrong in taking the statement in the manner that he did.
My only argument in that respect was that he never asked my client if he read or spoke the English language. He just began an interview without touching on that subject at all.
Did the standardized Miranda warnings end with the phrase, as I recall, do you understand the advice as I've read them to you? Was that included on tape, on the recording?
Yes, Your Honor. The key is that the accused has been made aware and fully comprehends that he has the right to remain silent in the face of police interrogation and to discontinue the dialogue at any time, and that the consequences of his waiver is that his words may be used against him later in the court of law. In Mr. Loran's situation, he actually testified at the motion to suppress, and that was with the aid of the interpreters and the translators. And Ms. Jackson, Ms. Michael, his trial attorney said, did you voluntarily waive his rights? Yes. Do you know what the word voluntary means? No. And then Ms. Michael had to go through again to try to help him define the word voluntary. And he's like, no, I did not voluntarily do this. I would not have given this information if I had known it was going to be used against me. Further, in the motion to suppress hearing, Ms. Michael points out that Mr. Mackey is usually not in uniform. He's a detective. He usually wears, plain clothes. However, he did have a badge, and he was unaware whether that badge was visible during the interview or not. So if Mr. Loran did not understand that he was in a custodial interrogation, well, because again, custodial interrogation is a difficult word, then he may not have knowingly and voluntarily waived those rights. On the record repeatedly, he says, I can speak day-to-day language, I can understand day-to-day English, but the harder words, I don't understand.
Which brings me to my next question, of whether or not it was ever asserted at any stage of the proceeding what words it was in the Miranda warnings that Mr. Loran did not understand.
He never said on record what those words were that were difficult. However, again, at the motion to suppress hearing, he did not know the word voluntary. And that is one of the key words in the Miranda, is that you're voluntarily speaking to the police.
But that's a legal review of the Miranda warnings. It is not, as I recall, in the Miranda, the word voluntary. And so I'm wondering, I mean, it is intentionally written in layman's terminology. And so how does that factor into our review of the suppression?
I would argue that the Miranda warnings, it took up the court's years to come up with the Miranda warnings. It is not simple language. There have been cases constantly in reviewing Miranda, people not understanding things, and for a non-native speaker to be told these things and have less than a 10-minute interview where he admitted to every element of the crime, I would argue that he was not aware that he had the right to remain silent about it.
When you say these were Miranda warnings, and that may be just what we're using, but the statutory ones, did it follow the statutory?
Yes, Your Honor. While he understands some conversational English, he is not fluent and he has difficulty with more advanced wording and legal terminology. At no point was he asked if he spoke or read the English language. He required, as we said, Marshallese interpreters at the court proceedings. Because the court even had concerns about his ability to be fluent in English, that's when the court appointed the two Marshallese interpreters. The person at trial that needed an additional interpreter, that was a witness for the state, had been in the United States for over 20 years, but still did not feel comfortable in a legal proceeding, answering questions in not his native language. This was not a simple misunderstanding of a few words. It was a failure to effectively communicate the essential constitutional safeguards that must be conveyed before any custodial interrogation. The state cannot meet its burden of showing valid waiver on this record. And this constitutional violation was not harmless. The state relied heavily on the interview. They referred to it in their closing arguments as a main reason to find the defendant guilty. And additionally, when the jury was back deliberating, the one note they sent was, "Can we watch the video?" And they were able to watch that video, and shortly thereafter, they returned their guilty verdict. There's a strong likelihood that appellants improperly obtained statements contributed to the conviction. The court should reverse on the first issue alone. The errors did not end there. The second issue involved a serious flaw in the jury charge on continuous sexual abuse of a young child. The legislature determined that this offense is worthy of an enhanced punishment range of 25 years to life without the possibility of parole, but only where the statutory elements are satisfied. One of these key elements is that the alleged acts of abuse must occur 30 or more days apart. Here, the application paragraph of the charge failed to properly instruct the jury on this essential element. Instead, it simply required a finding that the alleged acts occurred sometime within a multi-year span. It did not explain the acts must be separated by at least 30 days. As worded, the jury could have convicted based on a finding of acts occurring close in time, even days apart. Other courts have found that substantial similar language constituted jury charge error. And it was not a mere technicality. It deprived appellant of his constitutional right to have the jury determine guilt beyond a reasonable doubt on every element of the charged offense. The fundamental defect was magnified by the state's closing arguments, which prompted the jury to convict if any 2 counts occurred at any time without regard to the 30-day requirement. This was said multiple times in the closing argument by the state.
But the facts as shown at trial, and by the confession, was that these events occurred for a number of years, as I recall.
In the interview, he admitted to acts starting late in 2018, I believe, and I believe that child turned 14 in 2019. The alleged acts that they are saying led to the continuous sexual assault of a young child happened years before that time, and the testimony at that point would have been the child herself. There were no other evidence outside of the child's testimony in relation to those timelines.
Because what is the time period on which the evidence shows that the events could have occurred?
I believe the indictment is through December 2017 through December 2021. Since no objection was made, the egregious harm standard applies. The record establishes egregious harm when considering the entire jury charge, the state of the evidence, the argument of counsel, and other relevant factors. The erroneous charge vitally affected an essential element, and the state exploited the reduced burden of proof in its arguments. It deprives appellant of a valuable right in a fair trial. My third point of error, Your Honor, is, finding that appellant was indigent, and they appointed counsel after that, on a trial and appeal. The judgment orders appellant to repay all fees, which totaled over $8,000. Under the Code of Criminal Procedure, a trial court may order reimbursement of court-appointed attorney's fees only upon a determination that the defendant has the financial resources to offset the costs in whole or in part. The defendant's ability to pay is an essential prerequisite. No time after the trial was his indigency discussed any further. However, on the judgment, it say that he would be billed all costs of court. And recently, in this court, and it could be in the state that arose out of the 249 District Court, this court said that absent a hearing to reevaluate the defendant's indigency, that the defendant's presumed indigency remained intact. So we are asking that the judgment be modified to remove those costs associated with this case. We argue that he was denied fundamental rights to a fair trial, and that he is entitled to a new trial with his constitutional rights protected, including suppression of his recorded statements and proper jury instructions. We're asking that the court remand and ask for a new trial.
Counsel, one thing that I need to take up is both of y'all's briefing was from about cases around 2010 on the suppression issue. In about 2013, the Court of Criminal Appeals, and I think it was a case called Sandoval, and another case, I would say Alvarez, held that findings of fact are required when a motion to suppress the admission of a defendant were required, and actually reversed the Court of Appeals for failure to have findings of fact outstanding. It was not an issue in the case, no raised by either party. You might imagine that we don't like to be reversed, even if it's for something like that. And so, do you believe that those cases, and you may want to stop and think about this, and address it in your flow, but is there any reason that those cases would not apply to a requirement that we remand this case, abate it and remand it so that the trial court can do the fact findings and then take it up thereafter?
I would like time to think about that before I respond.
Thank you. Council, you may approach and do your 3 minutes to the audience.
And police report. It's relevant to issue number 1. RT, the record shows alleged that testified that abuse began in December of 2012. She was about 17. It intensified and it occurred quite frequently for about 4 years. It continued up until the week before he was arrested in the spring, I think in April of 2021. This would be significant in issue 1, because even if you suppress, or the judge should suppress the videotape, instead of the interrogation, then the defendant still, the victim still testified to all this abuse. And her testimony alone supports the conviction. Know that in a suppression hearing, the trial court is given almost total deference to the determination of historical facts. And the historical fact in this case would be, is the defendant deficient in knowledge? He got to see during the suppression hearing videotape, got to hear questions asked, questions answered, was it appropriate response? You got to hear testimony from the investigator. You got to hear testimony from Jenny Gilbert, who was a CPS investigator, who had dealings with the appellant. She thought he was deficient. Got to hear from the niece of the appellant. And I think they was. She said it was sufficient. Issue two. Truck court had an obligation in Article 3614. Three parts. First, you gotta get a jury, the charge of the jury. And in that charge, it has to set out the elements of the offense. It has to correctly give the law applicable to the case. It has to do so in a way that leads the jury properly and it prevents confusion. As Penal Code 21-2 is the continuing sexual abuse of a young child under 14 years of age statute. What's problematic, alleged here, is that it's the language during a period of 30 or more days in duration. The defendant committed 2 more acts of sexual abuse as a child under 14 years of age. Where the courts of appeals have trouble with this is, does the last act have to occur 30 days or more after the initial act alleged indictment? Or can a jury convict, or they can choose to think they have to convict if that last act occurred within 30 days of the first initial act of sexual abuse alleged indictment? Okay, I'm going to go turn and argue this. You may proceed, Ray.
Judge, as just mentioned, as far as issue 1, total deference is given to trial court as to the establishment of historical facts. And mind you, I am going on the fly on this because Jason was just recently and I've had to pick up here. So could you get that microphone close to me? So, excuse me if I'm not up on the specifics of the suppression hearing and whatnot, but the trial court got to see the defendant questions asked, and his answers in response, the videotape interview. He got to hear from investigator Mackey. He got to hear from Judy Gilbert, the CPS investigator. He got to hear from the niece. They all said he was proficient in English. And probably the most important of that is the judge getting to see for himself how the defendant or how responded to questions were they appropriate. So his finding that he was proficient, I don't believe is an abuse of discretion. It's you review to know the court's application of finding facts to its conclusion.
But since we don't have that, we have the findings of fact.
Okay, and I didn't know that. But even if he did abuse his discretion, it would be harmless because in that interview, he admitted to, touching between 2018 and 2021, he touched her vagina with his hand and or his penis 18 times. Well, she testified that this abuse occurred from 2012 December to spring 2021. So, and her testimony alone supports a conviction. So even if you take that out, you still have sufficient evidence for a conviction. But I think more interesting to me is issue number 2. And that is whether or not the application paragraph was jury charger, if it tracked the language of the statute. Because the language of the statute has already been passed, the legislation passed by the legislature. It has not been ruled to be unconstitutional for being facially vague. And so there's a rebuttable presumption that it is constitutional. And so, and what you have to use the inquiry is on facial constitutionality of the statute. If would a person, ordinary and common intelligence, and guess at the meaning of the statute, and or would they differ as to the application of the statute? That is the same analysis you use to see if there's jury charge here. As a Maryland Court of Appeals opinion term, they find that no jury is intelligent enough because they aren't educated in legalese such as attorneys and judges to understand the nuance of 2102. So it uses the ordinary reasonable person standard, just as you do in trying to determine whether the statute is based on constitutional. It's already held to be not vague, not confusing on a constitutional basis, and how then can you sit there and say, well, but it is vague and confusing to 12 members of the jury?
Well, counsel, there's no question that the abstract portion of the jury charge track the statutory provision. It's when we get to the application paragraph under section 8 of the jury charge, where dates and periods of time are set out. And specifically, the charge says from the evidence beyond reasonable doubt that during a period that was 30 or more days in duration, namely from on or about December 21, 2012 through on or about December 19, 2019. And the language as appearing in the charge, it is unquestioned that the period of time, December 21, 2012 to December 19 of 2019 is a period that is more than 30 days. But that is not what the statute requires for a violation of the penal code. It requires that date period, date range had to do with the period of time when the victim was 14 or less, and the defendant was 17 or more. And so the owner about time period is sort of relevant there. It's the fact that two events had to occur more than 30 days apart. And as I understand the appellant's arguments is that based on the way the application paragraph is worded, there is nothing that requires the jury to find that at least two of the events that he is charged with occurred essentially more than 29 days apart. And so therefore he was deprived of a jury finding on an element of the offense.
I remember the case, where the application paragraph did exactly that. And they said that was just a signpost for the jury we're making its application of the elements of the offense to, the acts of witness, to handle the problem with that. But are you aware of the recent case of Perez?
I'm sorry?
Perez versus State out of 13 Court of Appeals.
Yes, and the issue, different courts of appeal have gone each direction on whether or not it's error versus harm. And right now I can't remember if Perez it was harm or error, but
Perez was an error. It said no error, and it did say that this was the general law, or generally, application paragraph is not constitutional. I mean, it's not a jury charge error if it follows and tracks the statute. It pretty much reads it's absolute.
it reads what?
It reads it's absolute. There's no exceptions to it. It says it was passed by the legislature. And so it's constitutional until proven otherwise, it's not constitutionally vague and constitutionally vague. And then if the jury charge tracks it, there is no error.
And I don't think that they are arguing that the statute is unconstitutional. The argument is that the jury did not have to find the elements as set out in the statute.
Well, their brief hinges on Turner versus State Federal Court of Appeals memorandum of opinion. Perez is up for review, it hasn't been published yet, but when it does, yeah, it's pretty much solved this issue, but
Well, it doesn't solve it for us, but there's one from the 13th court, one is from, you said.
True. So this is why I think this is a more interesting issue. You know, part of the problem you have here is that you have two holdings. I mean, what Turner said was that the jury is not smart enough, they don't have the experience in legalities to understand the subtleties of 21-2. And I said they can find you guilty if the last act of sexual abuse occurred within 29 days. Or they could find you guilty if it was 30 days or more. But they took it away from the jury. There was no evidence that they were confused. They just said, we find jury charge error. You know, basically really on theoretical confusion. But in that case, I think it was 2 months worth of abuse. So, whereas Perez just basically says, it tracks the statute, there's no error. I personally think that that should not be an absolute. I think it's above presumption. The general rule is if it tracks the statute, it is not jury charged. But I mean, what if you get a jury note that says, we need some clarification on this language you're used to? Or you have a hearing on a motion for new trial, which a juror is unjustified, says we didn't report the text. Then you have a presumption. Otherwise, the general rule should apply. It tracks the statute, no jury charge error. And that was what ours did. It kind of with the addition of adding the on or around December 2012 to December 19, 2019, apparently she turned 14 on the next day. But even if you do find it's jury charge error, there's no objection to it. So it's their burden to show the error caused egregious harm. And once again, jury, her testimony happened from 2012 to 2021. That's a period within and beyond 30 days. You know, so either way, you know, her conviction or the jury's conviction supported by her testimony alone. So they can't meet the egregious harm standard. I mean, I admit that at this point, there are 4 courts of appeals that have ruled in unpublished opinions that cited Perez. And I think there's just Cameron and others that said no, the language of the 21-2 is just too confusing for a jury. So you track the statute, it's automatic harmful, jury charge error.
Any case authority that's actually used pattern jury charge?
I'm sorry.
Are there any reported cases that have tracked the pattern jury charge?
That track the pattern jury charge. That I don't know, I assume that that's what everybody does. Trial attorney always pulling the comments or whatever the case.
If only they had, I tell you, we've looked for that. We did not find any case that had tracked the pattern jury charge for this offhand. And the federal jury charge makes it very clear that you have to have, a finding, unanimous finding on more than two of the offenses that occurred, more than 29 days apart. And it says it out very clearly in the application paragraph, while it also tracks the, statute in the, abstract portion of the charge. Why don't we move on to the third issue?
I'm sorry.
Why don't we move on to the third issue?
Oh, third issue we agree, is just general practice, as the judges said. After trial, they attach the fines and fees onto the judgment without having a separate hearing to determine if emergency status has changed. I had read about that, and it's fallen on that ears. It comes up regularly, and I always agree that that was it. And I agree on this case as well.
Counsel, I have a question going back to the first issue. I heard you say that certainly the jury could convict her if, just on her, convicted the guy just on her testimony. What importance, if any, should we attach to the fact that the jury asked to see the video, actually view the video, and then had it repeated during the closing argument?
I'm sorry, I'm having a hard time.
Well, I'm thinking it was going to be closed on my face, because have a reverberation, when you see that way, right? You mentioned that the other explanation jury could found guilt based on the testimony of the victim. What importance, if any, should we attach to the fact that the jury requested to see the video, actually view the video in the jury room, and that the video was mentioned again by the prosecutor during closing arguments?
Well, that would be an issue. This was sufficient evidence. But I was not ready, so I don't think. And I said, but make it so because you will the part of say this is it occurred. I mean, the purpose of statutes is instead of having 500 accounts of aggravated sexual assault of a child going over all these years, that you just took a two initial, and then one after they occurred 30 days more after that. She proved that out in this. I think if it wasn't sufficient evidence, argument, you could say the evidence was overwhelming. You should have to continue to have day 1 to day 29, day 30, on to for about 9 years.
Thank you, Counsel. Anything else?
Okay, please support.
You may proceed.
In regards to your question about the motion to suppress and the lack of facts finding, I was unable to find a specific case, but I did find Texas Criminal Appeals at Estrada. It's an older case, but it does say that when there's not a findings of fact, then the appellate court looks at the evidence in the light most favorable to the judge. So I would say that we can still look at the evidence from the motion to suppress hearing and the information gained from that and reverse based on his lack of knowledge of the English language. So the Court of Appeals are split on my second issue. But I would argue that this case, it was especially egregious due to the closing argument of the state. And Ms. Miller actually said in closing, quote, "I want y'all to remember that when we're talking about continuous sexual abuse of a child, there's 4 different ways that we've alleged." And she goes over different ways that it's alleged. It can be 2 times that he did this, it could be 2 times that he did that. It could be one of each, it could be something else, whatever. You don't have to write it down on this form over here. Y'all all just have to basically raise your hand and all agree that it happened at least twice. At no point does she say at least twice, with at least 30 days between. She just said, you've heard all these allegations, you've heard that these offenses may have occurred, or that they did occur. All you'll have to agree is that 2 of them occurred at some point.
Was there any objection to that argument?
There was not, and that's why the egregious harm standard is applied here.
Well, the egregious harm standard goes to the charge area.
Sorry.
And so I'm just curious if anybody objected to this, what you're now characterizing as an offensive argument.
No, the defense did not object that. And again, I would argue on my first point, that the incorrectly or the illegally assessed, interview conducted by Officer Mackey, that the jury weighed greatly on that. That was the one piece of evidence that they requested to review prior to finding him guilty. So, there was evidence, her testimony said this, and this, but they didn't ask for a transcript of her testimony. They asked to review the video again. And so, again, we asked for the remand and the new trial, with the motion to suppress graded.
Thank you, Councilman. I'm gonna go ahead and have a seat. I'm gonna give you a little bit of instruction here. But I've got 2 sites. One is Vasquez versus State, 411 Southwest 3rd, 918. The other is Sandoval. $665 Southwest 3rd, 496, both Texas criminal applications. I need y'all to read the question of whether or not we are required to debate and remand for the trial court to enter findings of fact and conclusion of the law. Given the fact that we have done the oral argument today, I need it done very quickly. Is there any reason it doesn't have to be a lot of briefing? I'm talking page or 2. Any reason y'all can't get that done by Friday?
Can I please have it till Monday? I have a lot of courts that stack up on here.
Do you need Friday week?
That would be preferable.
Okay. I hate to tell people to work on the weekend before shoulder. That work for you, Mr. Brown?
Okay, so I have to.
Okay. All right.
Let me ask one quicker. Since we're asking about whether we have to evade back to trial court findings of facts, or whether we can proceed with what's customarily done with implied findings, and the trial court doesn't make explicit findings of fact. Maybe add that to the mix if you don't mind.
And with that, obviously, under the rules, you need to supplement your briefing with any cases that you cited that were not included in the briefing, but I don't recall that, although might have cited one. Anyway, it doesn't matter. This case is submitted and y'all are excused, and thank you for coming all the way across the district. Katie Corner is about 3 hours. So thank you. This time, before the stand adjourned until the 1 o'clock, 1:30. Apologize. Excellent job. I couldn't even remember Matt's name, so you couldn't fill that.
Thank you so much. It was everything.
Are you gonna be at lunch?
Yes.
Okay, we'll see you in a bit.
Thank you.
Thank you. Second place. Yeah, thank
You guys have any programs?
Okay.